So I'm here to tell you a little bit about immigration. And ultimately, immigration is about two questions. Question one is, who do we admit to this country? And question two is, who do we expel from this country? So let me start with the first question. There are four categories of people who come to the border seeking entry. The first is lawful permanent residents. These are people who come to the border with permission to stay here permanently, typically based on family ties or employment. The second is temporary visa holders. These are, like the student visa holders who come to Stanford, people who come here for a specific purpose and a specific period of time, after which their permission ends. The third category is asylum seekers, and we've been hearing a lot about asylum seekers in the media. Asylum seekers are people who come to the border without a visa and ask the United States to allow them to come in because they face persecution abroad. And then the last category is people who come to the border without a visa and who cross without permission. Those are the four categories. And anyone in those four categories can also be deported or expelled. So, for example, lawful permanent residents can be deported if they accrue certain criminal convictions, even minor convictions. Temporary visa holders can be deported if they don't leave after the terms of their visa end. Asylum seekers can be deported under certain circumstances, and people who are here without papers can be deported because they're here without papers. So what is deportation? Well, the really important thing about deportation is that it is civil and not criminal. Let me explain that. So normally, when the state wants to impose punishment, and here I'm talking about jail or prison, the state has to give you certain protections under the Constitution. If the County of Santa Clara wants to put me in custody on a criminal basis, I have to get appointed attorneys to represent me for free if I can't afford a lawyer. I get a trial by jury. I get an impartial adjudicator as a judge. I get to see the evidence that the state has against me. I get all of these things because the Constitution requires it, and I get a lot of other protections as well. What happened in the late 1800s and early 1900s is the Supreme Court considered the Chinese exclusion laws, which are racist laws to keep out Chinese immigrants. And as part of considering those laws, the Supreme Court held that deportation is not legally punishment. Now that sounds crazy to me and to all the people I represent and my students represent who are in deportation proceedings. It sure feels like punishment to be separated from your family and your community and your friends. But as a legal matter, it's not considered to be so. And what this means is that there's kind of a Constitution light that applies in deportation proceedings. You don't get a right to appointed counsel, even if you're a child in deportation proceedings. You don't have a right to trial by jury. You don't get an impartial adjudicator. You don't get to see the evidence that the government has against you. And all the protections you get are at a lower level and defined by the Due Process Clause. Okay, so now on to the question I get pretty much every week since inauguration, which is, can you do that? And the answer is really about the limits of executive power. And so one place where we've really seen a lot of activity is in the courts. The courts have stepped in, especially the federal courts, in many different cases to consider what the limits are on the Trump administration's immigration policies. And there are three different ways in which courts have considered limits. The first way is constitutional limits. So an example of this is the zero tolerance or family separation policy that's been all over the news over the last summer and until the present. A district court judge in San Diego held that the family separation policy violates the Due Process Clause because there's a due process right to family integrity. So that's an example of a federal district court judge putting a limit on the Trump administration's immigration policies based on a constitutional claim. But there are other kinds of claims as well. Another kind of claim is a statutory claim, a congressional-based claim. And here, the claim stems from the fact that the Department of Homeland Security that enforces the immigration laws takes its power from the statute. It takes its power from the power that Congress gave it. So courts can look at a claim that the Department of Homeland Security or the president has exceeded that power, has exceeded the power that Congress afforded it. So an example of this involves the Muslim ban. So the Muslim ban was enacted through executive orders and a presidential proclamation, and basically sought to limit or eliminate immigration from certain Muslim majority countries. And the courts that considered that looked at one kind of claim. They looked at other claims as well, but one of the claims they looked at was whether a ban like that exceeded the authority that Congress gave to the executive branch. And the lower courts said yes, but ultimately the Supreme Court recently issued a decision saying no, and the Muslim ban is now the law. But this is still a kind of claim that's often brought and considered by the federal courts. And then a third kind of claim is whether the agency violated its own rules. So the Department of Homeland Security, which enforces the immigration laws, has its own internal rules called regulations. And DHS agents have to abide by those regulations. So you could imagine, for example, if a DHS agent conducted a raid and arrested an immigrant using excessive force, that not only would that violate the Constitution and the statute, it would also violate the agency's own rules. So that's another way in which courts intervene to put a limit on executive authority. I want to posit, though, that there's something different about the current administration compared to previous administrations. And this is about a concept that I call the presumption of regularity. So the idea is that litigants have been challenging immigration policies for decades under Democratic and Republican administrations. But there's something different now. And the different thing is that courts, I think, are being more cautious about according the executive this presumption of regularity. Normally, courts assume that before the executive issues a policy, that DHS agents, Department of Homeland Security agents, are consulted about how the policy will be implemented on the ground. That DHS will check with DOJ, the Department of Justice, and with other stakeholders. That there isn't a racially tinged motivation behind the policy. But all of those assumptions have been called into question with this administration. We saw, for example, with the travel ban at all our country's airports, the total disorganization that resulted from a failure to check in. The same with the family separation policy and other policies. And Attorney General Sessions and President Trump have used racially tinged language and have had a disregard for the human suffering on the ground, which is different from their predecessors. All of those things, I think, make courts a little more willing to step in and put some limits on the executive branch's immigration authority. But it's not just the courts. Immigrant rights activists are also really focused on this election that's coming up, and parenthetically, you should vote. The election is very important for immigrant rights advocates because Congress has such an outsized role in immigration policy. Remember that it's Constitution light in deportation proceedings. And what that means is that there's a lot of space for the statute, for what Congress says. And so immigrant rights advocates are really focused on this election because it's a lot about what Congress may or may not do to restrict the executive. Another place where we've seen pushback against the Trump administration's immigration policies is at the state and local level. Now, we're a very divided country. There are red states and blue states and red cities and blue cities. But here in California, we're in a blue state, and Santa Clara County is a blue county. And so we have policies that are intended to protect immigrant rights. And they're called, in some cases, sanctuary policies. It's a bit of a misnomer. But the idea is that local police, so this is the Santa Clara County police officer or Palo Alto Police Department, should focus on criminal law, should focus on enforcing criminal law, and should not extend themselves into enforcing civil immigration law, and that limit protects immigrant communities. There are other ways in which states and localities have stepped forward. We've seen a huge increase in states and localities, including Santa Clara County and the state of California, in funding immigration defense. So remember that you're not entitled to an attorney at no cost in immigration proceedings, even if you're a child facing deportation. But now the state has stepped forward and said, we will pay for it. We will pay for an attorney to help to represent children or others, especially vulnerable populations, in deportation proceedings. So these are ways in which the states and localities have stepped forward to put a limit on executive branch power, particularly with this administration. I want to leave you with a lesson from history. So the time of the Chinese exclusion laws and other restrictive laws in our past in the immigration arena have taught us that precedent is enduring, and that what decisions we make now in the courts and beyond the courts stay with us for a really, really long time. So I think it's incumbent on all of us to look very carefully at what the courts are doing in this particularly challenging time. That's all I have. Thank you very much.